Justice Devendra Kumar Upadhyay, the Chief Justice of the High Court of Bombay, my former distinguished colleagues of the Bombay High Court, Justices Makarand Karnik, Madhav Jamdar, with whom I shared the bench for almost 6 months, and I think we did some good work there. And Justice Rajesh Patil, all judges of the Bombay High Court, my dear friend, Learned Advocate General for the state of Maharashtra, Dr. Birendra Saraf. We have many things in common. Star of today's program, the learned author, advocate and solicitor, Akhilesh Dubey. Publishers, Bharat Law House Private Limited. Eminent senior advocates, members of the bar, Sanghamitra and Mrs. Patil, distinguished guests, ladies and gentlemen. A very good morning to you all. It's 11:45. It happens with me most of the time. Though my schedule is always in the forenoon session, by the time my turn comes, it is post-noon. So always I have to change from good morning to good afternoon. Luckily today is still in the morning hours. I'm very happy here to be present here this morning, to be part of this book release function of the book Treatise on PMLA, Law and Practice, authored by Sri Dubey and published in 2 volumes by the publisher, Bharat Law House. PMLA, that's Prevention of Money Laundering Act 2002, is the most contemporary subject in recent times. Law on the subject is evolving, and therefore the need for legal literature. The 2-volume book is a labor of love of the learned author, who has taken great pains in researching through various provisions of PMLA and the related case laws. I compliment him for writing this book, which I am sure will be very useful, not only to the bar, but to the bench as well, and also for officials of the Enforcement Directorate, who have been given the task of implementing the provisions of PMLA. I thank all those who helped Sri Dubey in this highly creative endeavor of his. Dubey has suffered some personal setback, but he has successfully overcome this, and this is the achievement of his hard work. I therefore compliment him. Well, Mr. Dubey, the story of everybody may not be similar, but the life is very uncertain. It's not even. People face difficulties in life. People face setbacks in life. But how you overcome that, how you face the challenges, that is the true test of a person's character. So in this, I think the author has come out with flying colors. Thank you. Congratulations. I also take this opportunity to compliment the publishers, Bharat Law House, for publishing the book. Friends, as in movies, where we have behind the scene or behind the camera, various players whose contribution to the making of a film cannot be understated. Similarly, the role of law book publishers in the legal field cannot be ignored. Be it the profession, be it the courts, or be it the academia, law books and by extension law book publishers play a significant role. They are a vital clog in the administration of justice. Despite advancement in technology, law books are here to stay. One cannot think of a lawyer's chamber without books. Therefore, we must acknowledge the role of law book publishers in the life of law and justice. The field of law and justice would be incomplete without the silent contribution of the law book publishers. My congratulations to Bharat Law House for publishing the book, that too in 2 volumes. regarding writing a book, Brother Patil has said something. I wish and I pray that he completes the assignment and brings out the book on Hindu law, which will be of great help to the practitioners of Hindu law. Well, writing a book and choosing a topic, I remember a discussion I had, or a talk I had with my then Chief Justice, Justice Ajit Singh. He was my Chief Justice. He is the son of that legendary G.P. Singh. So he was telling me about his father. He said that his father was initially inclined to write a book on Constitution of India. Later on, he realized that already the field was covered, as we say in law, occupied field. So he found that D.D. Basu's commentary was there, and so many. So after some thinking, he decided that he will write on interpretation of statutes. So G.P. Singh's statutory interpretation of this statutes is now a legend, actually. This is the book par excellence on the subject. I pray and I hope that Dubey's book on PMLA will also achieve the stature of Justice G.P. Singh's book on interpretation of statutes. Justice Gawai, Judge Supreme Court of India, and all and he's our senior, esteemed senior, and our guide, friend, philosopher, and guide. He has written a very inspiring foreword. Justice Makran has also penned a very detailed and analytical introduction. This is an acknowledgement of and tribute to the hard work and competence of the learned author. Well, friends, before I say something, I must put in a caveat. As I said, PMLA is a live issue. And to put it, it's a hot issue, like a hot potato. Cases under the PMLA are hotly contested. And for whatever reasons, many of such cases have acquired political overtones. Being a sitting judge of the Supreme Court, matters arising out of PMLA are regularly listed before my bench. Therefore, I will only confine myself to the text of the law and a few of the decided cases. Well, Justice Jamdar has referred to money laundering, the Black's Law Dictionary. It says, money laundering is the act of transferring illegally obtained money through legitimate people or accounts so that its original source cannot be traced. In the United States, it's a federal crime. Justice Karnik has explained money laundering in simple terms. Just as laundering refers to cleaning clothes, money laundering involves cleaning money obtained through illegal activities by using it for legitimate purposes. It's a complicated offense, no doubt about it. It is not only multi-layered, but it is also a continuing offense. Adding to the complexity, many PMLA cases have got transnational ramifications as well. Essence of money laundering is introducing crime-tainted money, which is textually referred to as proceeds of crime, into the regular economy, and in the process, make such money appear as legitimate. The author has delved into this aspect and has noted that there are 3 stages in the process of money laundering. The first stage is placement. In this stage, the illegally acquired dirty money, we call it that way, dirty money, or the proceeds of crime, are moved from its original source into the legitimate financial system. In other words, money acquired through criminal activities is successfully introduced into the legitimate financial system. Next comes the layering stage. In this phase, the proceeds of crime are concealed or disguised Such proceeds may be invested in respectable business ventures. At this stage, services of shell companies may be utilized. Money accruing out of such investments would therefore appear to be earned legitimately. The final stage of money laundering is integration. It is the stage where proceeds of crime are reintegrated into the legitimate financial system and mixed with other assets acquired through legitimate sources of income. Thus, the trail or trace of the crime money gets obfuscated or erased completely. As I said, there is an international dimension to money laundering. One of the concerns of different countries related to laundering of proceeds of crime arising out of illicit traffic in narcotic drugs and psychotropic substances. It was observed that such type of money laundering posed a serious threat not only to the financial systems of the countries, but also to their integrity and sovereignty. Therefore, a convention was held in December 1988. It's called the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances. It is also known as the Vienna UN Drug Convention. And a treaty was signed thereafter by 43 countries. This convention not only declared money laundering as an offense, but also made aiding and abetting of money laundering as an offense. A financial action task force was also formed in the summit of 7 major industrial nations, G7 as we say. And the focus of this task force, and it continues to be so, is to tackle the menace of money laundering. Friends, money laundering is no longer associated with drugs. Though internationally, it still poses the major threat. It is now associated with all kinds of illegal activities and crimes, both transnational and domestic. If I take a digression for a moment, if you look at the international crime scenario, the broad international crime scenario, drugs and narcotics is now no longer the numero uno, as you can put it this way, in the world of crime. Maybe because of the stiff penalties imposed in many of the countries, particularly in the Southeast Asia. It is now being replaced by crimes relating to wildlife crimes, crimes relating to human trafficking, crimes relating to guns and weapons. So these are the 4 major areas of worldwide crime having transnational ramification. So it's not only now drugs, the net has become that much more wider. There are various other international developments relating to money laundering, such as successive reports of the Financial Action Task Force, the Strasbourg Convention, the Basel Committee principles, so on and so forth. For paucity of time, we will not go into that. Suffice it to say that the United Nations General Assembly held a special session, and in that a resolution was adopted calling upon the member states to adopt national money laundering legislations and programs. To implement the above political declaration, the Indian Parliament enacted the Prevention of Money Laundering Act 2002, that is the PMLA, which came into force on 1/7/2005. PMLA has undergone several amendments since 2002. Some of the amendments are under challenge before a larger bench of the Supreme Court. I think the case is Roger Matthews, subject to correction. On various grounds, these amendments have been challenged, but primarily the ground is that amendments to PMLA could not have been enacted by the Parliament by way of a Finance Act. since the issue is sub judice, I would refrain from making any comment thereon, because this is a very live issue. Sooner or later, this issue will have to be decided one way or the other. Friends, if you look at the scheme of the PMLA, it can broadly be divided into two parts. The first part relates to civil consequences, and the second part deals with arrest and criminal prosecution. Be it provisions relating to attachment of property or provisions relating to search and seizure, arrest, etc. The sine qua non for setting the provisions of PMLA in motion is the reason to believe of the authorized officer that the concerned person is involved in the offense of money laundering and is in possession of any proceeds of crime. The offense of money laundering is provided in Section 3, that's the offense defining section, and the punishment is provided in Section 4. So, without entering into specifics, we can broadly say that a person would be guilty of committing the offense of money laundering if he is involved in any process or activity connected with the proceeds of crime and projecting it as untainted property. Now, proceeds of crime, as per the definition clause, it means any property derived or obtained by any person as a result of criminal activity relating to or relatable to a scheduled offense, an offense which is there in the schedule. The offenses mentioned in the schedule includes offenses under the IPC, under the UAPA, under the NDPS, under the Wildlife Protection Act, so on and so forth. Such proceeds of crime would also include any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to the scheduled offense. Simply put, to constitute the offense of money laundering, number one, there must be proceeds of crime derived from or obtained as a result of criminal activity relating to or relatable to a scheduled offense. So therefore, the second requirement is that there must be a scheduled offense. Then there must be proceeds of crime derived from or obtained as a result of criminal activity relating to or relatable to a scheduled offense. Finally, the person concerned must be involved in any process or activity to project the proceeds of crime as untainted property. It is only on fulfillment of these above three conditions, ingredients, that the offense of money laundering is committed. While I was in Telangana, in one case, Vijay Sai Reddy versus Enforcement Directorate, I have said that the expression proceeds of crime, which is the very essence of the offense of money laundering, needs to be construed strictly. Only such property which is derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offense can only be regarded as proceeds of crime. In another case, my bench in Manturi Shashi Kumar versus Directorate of Enforcement, it held that authorities cannot resort to any action against a person under PMLA for money laundering on an assumption that the property recovered by them must be proceeds of crime and that a scheduled offense has been committed unless the offense is registered with the jurisdictional police or is pending inquiry. Now the punishment, as I said, is in 4. It's not less than 3 years, but which may extend to 7 years, and with fine. Initially there was a cap of 5 lakhs, now that cap has been omitted. If the proper officer has reason to believe that any person is in possession of any proceeds of crime which is likely to be concealed or transferred so as to frustrate proceedings under the PMLA, then under 5, Section 5, he may provisionally attach such property for a period not exceeding 180 days. Again, such provisional attachment is subject to confirmation by the adjudicating authority under Section 8. Crucial expression here is reason to believe, both at the stage of provisional attachment under 5 and during confirmation proceedings before the adjudicating authority under 8. It will not be enough only to say that there was reason to believe at the stage of 5. The reason to believe in 8 must be different. This interplay between this expression occurring in 5 and 8, I have explained in one of my judgments. I'm not going to repeat this. Now, this expression reason to believe is a crucial one, but it is not defined in PMLA. It's not a defined expression. But this expression, reasons to believe, finds place in several taxing and penal statutes, notably in the Income Tax Act. And this expression has received considerable judicial attention. Way back in 1960, in the context of reopening assessment under the old Indian Income Tax Act 1922, Supreme Court in the famous case of Calcutta Discount Company held that the income tax officer must have reason to believe that income had escaped assessment, income chargeable to tax had escaped assessment before he could proceed to reopen a concluded assessment. There must be a live link between the reasons recorded, which again must be on the basis of materials gathered, and the formation of belief that income chargeable to tax had escaped assessment. Then only he gets the jurisdiction to reopen an assessment. Such reason to believe must therefore be germane to the issue and should not be fanciful. Reason to believe cannot be equated with reason to suspect. The power to arrest is provided in Section 19. Here also the arresting authority must have reason to believe, on the basis of material in his possession, that such and such person is guilty of the offense of money laundering. In that case, he may arrest such person and inform him of the grounds of arrest. We'll deal with this a little bit later. Contrary to the presumption of innocence of the accused in regular criminal proceedings, there is a reversal of the burden of proof in Section 24. The presumption is that the person charged with the offense of money laundering is involved in money laundering. That is the presumption, that is the legal presumption. And that the proceeds of crime are involved in money laundering. Of course, this is a rebuttable presumption, but the contrary can be proved only during the trial, not at the stage where you are dealing with the bail. Though officers of Enforcement Directorate are not police officers, and therefore the bar of Section 25 of the Indian Evidence Act 25 says that no statement made before the police would be admissible in evidence. So this bar, because officers of Enforcement Directorate are not police officers, would not be applicable to them. Nonetheless, in a case arising out of the Foreign Exchange Regulation Act 1973, there also the implementing agency is the Enforcement Directorate. The Supreme Court in A. Tajuddin versus Union of India has sounded a note of caution that statements made to officers of the Enforcement Directorate ought not to be readily believed unless there is independent corroboration. Of course, that was in the context of a retracted confession. Supreme Court said that such statements can be easily thrust upon the person, either summoned or facing investigation. Now, then comes the most talked about provision, section 45, which is the provision for bail. There are two additional limitations. In addition to the normal limitations under the CRPC, we have two other additional limitations. In fact, to understand the rigor of this section, it needs to be pointed out that this section starts with a non-obstante clause, notwithstanding anything in CRPC. It starts with a non-obstante clause, and the entire section is negatively worded. No person shall be released on bail. So the section itself is couched in negative language. The two additional conditions, also referred to as twin conditions, are that number one, the public prosecutor should be given an opportunity to oppose the bail application. Number one, there's no difficulty there. Number two, if the public prosecutor opposes the bail application, then the court must, the burden shifts to the court. The court must record its satisfaction that the accused is not guilty of the offense of money laundering and that he is not likely to commit any offense while on bail. We'll deal with this aspect also. Power of issuing summons for production of documents and to give evidence is provided in section 50. Such power is akin to the powers vested in a civil court while trying a suit under the Civil Procedure Code, and is to be exercised in respect of discovery and inspection, enforcement of attendance of any person, examining him on oath, etc. As was pointed out earlier, a two-judge bench of the Supreme Court examined the validity of section 45 in this case of Nikesh Tarachand Shah versus Union of India. The bench of Justice Rohinton Nariman and Justice Sanjay Kishan Kaul examined the said provision which imposed the twin conditions of grant of bail. At that time, it was provided that the offense punishable for a term of imprisonment of more than 3 years under Part A of the schedule. The bench referred to the object of bail as set out in Gurbakh Singh Sibia's case, the Constitution Bench judgment, and quoted Justice Krishna Iyer, and I quote, "The issue of bail is one of liberty, justice, public safety, and burden of the public treasury, all of which insist that a developed jurisprudence of bail is integral to a socially sensitized judicial process." Supreme Court referred to Article 21 as the Ark of the Covenant so far as fundamental rights are concerned. Though our Constitution has no due process clause or the 8th Amendment as in the US, but when it comes to the question of right to life and personal liberty of the citizens of India, following the law laid down by the Supreme Court in Cooper's case and Menka Gandhi's case, the consequence is one and the same. So therefore, following on this, in Nikesh Tarachand Shah, the two-judge bench declared section 45(1) of PMLA insofar as it imposed two additional twin conditions for release on bail as unconstitutional, as it violated 14 and 21, Articles 14 and 21 of the Constitution. This is a judgment of 2018. 2 years later, a three-judge bench of the Supreme Court in Vijay Madan Lal Chaudhary reversed it. The three-judge bench dealt with various challenges to different provisions of PMLA, including the amendment of 2018, whereby Parliament amended Section 45 after the decision in Nikesh Tarachand Shah, removing the defect and reviving the twin conditions. The three-judge bench upheld the amendment which came into effect from 19/4/2018 and thereafter declared Section 45 as reasonable and constitutional. In fact, all the challenged provisions of PMLA were declared constitutionally valid. Friends, Vijay Madanlal Chaudhary is now under consideration of the Supreme Court as to whether it should be referred to a larger bench. So again, it would not be proper and prudent to discuss and dilate too much on Vijay Madanlal Chaudhary. In Senthil Balaji, in this case, again a two-judge bench of the Supreme Court held that this is regarding arrest. The authorized officer, while arresting a person, must perform the mandatory duty of recording reasons, and this should be followed by serving the information of the grounds of arrest on the arrestee. But the bench stopped at that and did not elaborate further as to how the information should be served upon the arrestee. The question as to how Enforcement Directorate is required to inform the arrested person of the grounds of arrest has been undecided by a two-judge bench of the Supreme Court in Pankaj Bansal. The bench noted that no consistent and uniform practice was being followed by the Enforcement Directorate in the country. In certain parts, written copies of the grounds of arrest were furnished to the arrested persons, but in other areas, such practice was not followed. The grounds of arrest were either read out to the arrested persons or allowed to be read by them. So, to give a true meaning and purpose to Section 19(1) of PMLA, the bench in Pankaj Bansal held that henceforth a copy of the written grounds of arrest should be furnished to the arrested person as a matter of course and without exception. In all cases, the written grounds of arrest must be furnished to the arrested person. A little later, 2 months later, a coordinate bench of the Supreme Court in a subsequent decision in Ram Kishore Arora took the view that Pankaj Bansal would be prospective, as the word used in the said decision is henceforth. The same need, without getting into specifics, I would say that we need not be detained by this decision, inasmuch as even as per this decision, post the decision in Pankaj Bansal, the authorities of PMLA, Enforcement Directorate, are under a legal obligation to serve upon the arrested person the written grounds of arrest. There is no dispute on that. Only dispute is that this would not be applicable to the arrest made prior to Pankaj Bansal. Well, there can be several views on this. I would not disclose or discuss what is my view. As and when a matter comes up, now we have two coordinate benches decision, equal strength. I'm sure the wisdom and discretion of the benches hearing matters will guide them how to deal with a matter and adopt that view which is more consistent with our constitutional philosophy as mandated in Article 21. Friends, the law on PMLA is evolving. The last word is yet to be spoken. Therefore, there is enough scope for subsequent editions, including revised editions of this book. And as was pointed out earlier, as and when the revised edition comes or later editions come, I'm sure the publishers and the authors will again invite us and again invite all of you to share our thoughts and views on the PMLA. In the meanwhile, all that we can hope and pray is that the law would be applied judiciously. A number of benches of the Supreme Court, I can recall the bench of Justice Sanjay Kishan Kaul and Justice Sudhanshu Dhulia on one particular occasion, then the bench of Justice Surya Kant and Justice K.V. Vishwanathan on another occasion. They have observed in the course of hearings that there is a need for restraint and transparency. Friends, PMLA is a potent weapon in the fight against crime-tainted money. It is very much necessary to fight the menace of money laundering. But we all know that a weapon loses its potency if it is overexposed or over-applied or even misused. If that happens, there may be a negative perception about the actions of the Enforcement Directorate and by extension PMLA. If this happens, then it is the community and by extension the nation which will suffer. Again, pausing for a moment, it's a well-accepted principle in law that stiffer the procedure, criminal procedure, the higher will be the level of judicial scrutiny. There's nothing wrong in that. The objective is always to ensure that in the process of prosecuting and punishing the guilty, the innocent person should not suffer. If he has suffered, the sufferance should be minimized to the extent possible. That's the object of legal intervention of the constitutional courts. We hope and trust that all the stakeholders will apply the law in its true spirit, having regard to the objective of the legislation and keeping in mind the overarching constitutional mandate of Article 21 of the Constitution of India. My best wishes to the learned author and the publishers. Thank you very much. Thank you, all of you, for sparing this Sunday morning and to be here. And God bless you. Thank you.